Hello my friends, welcome to the sixth video of the legal theory concept. I, Foram Patel, would like to welcome you all very warmly. Now, in the previous videos my friends, we discussed about the concept of the rights, the definition of the rights, the kinds of the rights, the concept of the duties, the definition and the kinds of the duties, the concept of the wrongs, which is of course correlevant as the rights and the duties. Then we discussed the status of different entities such as drunken, dead, minor, lunatic or unborn individual. After that we discussed the concept of the title, which is the fifth element according to Salmon of the rights. So after that, when we are discussing the concept of the rights and the duties, my friends, that makes us think that if the rights and the duties are not fulfilled, then how would you constitute that in the general law? What would be the liability part? Whose responsibility would be that? So, to discuss that aspect under the jurisprudence, this session is dedicated. In this session, we shall be discussing different elements to constitute the liability, starting with, of course, the meaning of the liability and then the kinds of the liability. So, let's get started. So friends, as you can see on the screen, liability is responsibility for an act or an omission. Whosoever commits a wrong is said to be liable for it. So friends, till now we discussed the concept of the rights and the duties and the wrongs. But what if that wrong has already taken place? What if the duty is not fulfilled? What if the rights is already violated? Then the court, or rather the person, needs to determine the concept of the liability, that who is the wrongdoer, and if that individual is a wrongdoer, then what liability does that person have, or whose liability would that be? According to Salmon, my friends, liability or responsibility is the bond of the necessity that exists between the wrongdoer and the remedy of the wrongdoer. That means, my friend, the liability talks about different elements that were there while violation of the duty or the wrongs, and also about the remedies that will be lying after the violation of those rights. Now my friends, according to Markey also, the word liability is used to describe the condition of a person who has a duty to perform. So that means that liability, according to all these jurists, is the condition which will be there after not fulfilling the duties or doing something wrong. So it will be an after effect of those concepts. So as I stated that we will be discussing about certain different elements or certain different concepts or aspect of the liability under this chapter, we should not forget the very important aspect of the mens rea, the negligence and the intentions, which is there determined and discussed under the concept of the jurisprudence. Let's get started with the discussion of the mens rea as a very important element to create the liability. Now friends, what do you mean by mens rea? Mens rea is basically a guilty mind, which is of course which will further create the liability part on any individual. Whose guilty mind was that? If that individual did that act which is wrong, did that person have guilty mind at that point of time? These questions must be considered while you are putting liability on any individual. Now an act is punishable only if it is done intentionally or negligently. Intention and negligence are the alternative forms in which the mens rea can exhibit itself. That is the reason I shall be discussing both this concept after the concept of the mens rea. The conditions of the penal liability, the act does not constitute a guilt unless it is done with a guilty intentions. So my friends, doing some act is not wrong, but what you had in mind, did you have guilt in your mind at that time? Did you have bad intentions to hurt somebody? That constitutes the liability part. Two things are required to be considered in this connection, and those are the act and the mens rea, or rather the guilty mind of the doer of the act. Mens rea requires the consideration of intention and negligence both. The act is called material condition of the penal liability and the mens rea is called the formal conditions of the penal liability. Now it becomes very important for all of us to understand that mens rea must extend to all the three parts which is there to constitute an act which is punishable. The physical of doing or not doing some act, the circumstances and the consequence. For an example, my friends, I am standing on the road and the accident takes place. Now, I am not doing anything in that. I am letting the person suffer after the accident. So, did I have a guilty mind at that point of time for not doing something morally that I should be doing? So, physically doing something or not doing something would be first consideration. The second is the circumstances. What if I wanted to go but then I had to reach at a place consequently at the time just right after that, and so without wasting my time I had to be there, and that is the reason I could not take that step. The consequence of that, if the consequence of that is very bad, then the first two elements must be determined at a very rightful way so that the liability on the basis of the mens rea can be established. But friends, what if the guilty mind was not there? What if the act was not done intentionally to hurt somebody? So, when we are discussing the concept of the mens rea, we must never forget that there has to be certain exceptions to this concept. Now, the exceptions that you can see on the screen are the first one, if the act which is done is for the public safety, health, social welfare or such concerning matters. That means, my friends, that if I allow something to happen, or rather I do not act as I should be acting, doing my duty of course, then if that consequently means to protect the public at large, or it is for the social welfare or any other such concerning matters, then that would constitute one of the exceptions of the concept of mens rea. Second one, where mens rea is difficult to be proved, it need not to be proved provided the penalties are petty fines. So that means, my friends, that if the matter is very petty, then and you're not able to determine the mens rea, then you do not have to put your efforts into it because the penalties are already there and it is very petty. So that would not make any difference. The third one, in the interest of the public safety, it may not be considered when deciding the case of the public nuisance. If you are doing or not doing some act for protecting the public, or rather avoiding the public nuisance to take place, then that would create one of the exceptions of the mens rea concept. The next is, my friends, that when the act is criminal in form but in fact are only summary mode for enforcing civil rights. That means if I am trying to enforce my civil rights by doing some act or not doing some act, and that consequently harms something, or rather it consequently results into something which is criminal in form, then that would not mean that I had guilty mind while doing that act. I did not have any mens rea because what I was trying to do was only trying to enforce my civil rights, which was lying at my individual's existence part. The next exception, my friends, is this: ignorance of law is not an excuse. That means ignorantia juris non executa is another exception to the rule. That means, my friend, that I cannot state that part. If I have violated the red light rule of the traffic, then I cannot say that I was unaware about that rule. If I am stating that, then that can never be an excuse. Then the mens rea will not be taken into consideration. It will be an exception to that. You cannot have the ignorance towards the law which is there in existence. Ignorance to fact may be taken into consideration once in a while, but not the ignorance to the law, my friends. So this was the concept of the mens rea along and how it was relevant with the concept of the liability and certain exceptions to that concept. Further, in the next video, we shall be looking into the concept of the intentions and the negligence along with the kinds of the liability. Till then, keep learning.